Now it's time for On Point. Yesterday, a decision was handed down by the arbitration body of the World Bank on a decade-old legal dispute between the South Korean government and the American private equity firm Lone Star. The ruling said that South Korea owes Lone Star some $260 million for interfering in the firm's sale of Korea Exchange Bank to another local bank.
That's right. That amount is less than 5% of what Lone Star initially claimed. But the one person that the decision possibly matters the most to says it's 5% more than what's fair. Take a listen to Justice Minister Han Dong-hoon and a brief rundown of how the case unfolded.
The government will be going over a response, including an annulment request. The government will do its best. Not a dime of our precious taxpayers' money can be wasted.
This was a decision made by the World Bank arbitration body, which decided that South Korea had deliberately delayed the transaction process and denied the American private equity firm more profit. This is a decade-old dispute. In 2012, Lone Star Funds filed a complaint for an investor-state dispute settlement saying, first, South Korea purposefully delayed the sale of Korea Exchange Bank to HSBC in 2007, which led to the deal falling through. Second, South Korea taxed Lone Star unfairly, going against treaties made between South Korea and European nations. Third, South Korea delayed the process of KEB sales to Hana Bank back in 2010, ultimately lowering the final price. South Korea said its financial regulatory agency treated all transactions by Lone Star fairly and that all the delays were due to the allegations against the fund for stock manipulation and other potential criminal activities. In the end, the three-person tribunal panel unanimously dismissed the first two claims. But for the last one, two of the three accepted Lone Star's claim. However, the nation's highest court said in 2012 that Lone Star, in fact, is guilty of illegally meddling with Korea Exchange Bank's credit card division. That's why a partial amount was granted, $260 million.
Seeing that the tribunal's minority opinion fully accepted our government's claim, denying any responsibility, we see a reason to take this to the very end.
So now we invite Andrew Lee, a partner of a US global law firm, to dig deeper into the issue. Very good morning to you, Mr. Lee.
Yep, pleased to be here.
Right, thank you for joining us. And well, first of all, there's been some mixed reactions to this decision. And as an attorney, who would you consider the real winner in this case?
I think there will be a lot of debates coming out of this decision. I think on surface, many observers believe that Korean government has fared much better than expected. But in reality, I think you have to assume that both parties, in this case, including Lone Star, will feel that they have not fared well, and therefore will consider their next steps carefully. It is true that in terms of the award amount, the amount essentially stacks up to less than 5% of the claimed amount by Lone Star. If you consider that the damage award likely included both pre- and post-judgment interest, which the arbitrators must account for, then the damage on the merits, meaning the specific substantive claims that Lone Star brought to the table, would have been much less than $216 million. Even though the decision is not public, so we haven't seen it yet. Typically, especially given the length of these proceedings, in this case, we expect the pre- and post-judgment interest to have been material amount of damage, and therefore you could see this the damage award amount on the merits themselves would be even less than perhaps $200 million. So all in all, this appears to be a good decision for the Korean government. And then, although we haven't seen the decision, it's also possible when it comes to light that because this was predicated on the Belgium, Luxembourg, Korea bilateral investment treaty, and that treaty only came into effect in March of 2011, which some of the events that have occurred predated that. Some have occurred after that. So arbitrators may have had some wiggle room to decide which of the impact on the transactions may not have been subject to the treaty and which one would have been subject to the treaty. So there's a lot of different substantive arguments that they could have accepted. And so that is another consideration or factor we need to look into once the decision comes to light.
Right.
And then on top of that, there are a few arbitrators that were appointed to the panel that were broadly seen as investor-friendly, such as Mr. Charles Brower or V.V. Veeder. So those people, so given the what were, the people who were broadly seen as investor-friendly, I think this decision is also a reasonably good one for the Korean government. So all in all, even though, of course, both parties will feel that they have lost in certain parts of the case, it does look like, in overall, generally speaking, that given that BITs are bilateral investment treaties exist for the protection of mainly of investors, I think this decision can be seen as a reasonably good one for the government.
Right, and I just wanted to reiterate that the decision is not open yet from World Bank. We are getting information off of Justice Ministry, but the dispute was settled through arbitration, meaning it was not actually a loss. And many people don't know the exact difference between the two. So how enforceable is this decision? Do we really have to pay $260 million because World Bank says so?
I think the short answer is yes. Korea became a contracting state to the convention called New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So the Republic of Korea joined that convention back in 1973. In fact, it was one of the earlier states that have joined that convention. And in effect, to put it simply, the convention essentially says that if the contracting state faces an foreign arbitral decision, then that decision will be effectively seen as recognized and enforced in any contracting member state of the convention. So, for example, if Lone Star had this award in hand and came to Korea to present that decision to the Korean court, then Korean court must, under the convention, recognize and enforce that decision. Should the Korean court, for whatever reason, refuse to honor that decision in Korea, then Lone Star is also under the convention entitled to go to any country who is a contracting member state to the convention and present that decision to a competent judicial body in that contracting member state and try to enforce that decision. So it is a pretty robust convention and is well supported by prior precedents, and so this will be a fairly easy enforcement proceeding for Lone Star. On top of that, of course, Republic of Korea is also belongs to as a member to the World Bank, and so ICSID is part of that, and so refusing to honor the decision of ICSID will also impact Korea's operations and including as beneficiaries of any privileges that it obtains from World Bank. So there are a number of avenues that Lone Star can pursue to enforce this decision at the end of the day.
Right, and while we have you here, we also wanted to shed some light on something that you might be best placed to answer. And well, the case has been going on for 10 years with different law firms in Seoul and Washington involved, and the cost incurred by the South Korean government must have been pretty significant. Can you give us a ballpark figure?
Yes, as a practicing attorney, of course, I always, become a little bit cautious in talking about costs. Which are highly predictable and unknown when you have such high stakes cases like this case. But generally speaking, as a sort of a ballpark figure, you will see in multi-year disputes and arbitrations like this, there will be heavy ebbs and periods of ebbs and flows. But in periods of intensity, which would have involved multiple years in a case like this, it's not uncommon for the companies or governments to see a monthly bill that exceeds $1 million. It's not uncommon at all. So, so if you assume that the proceedings were multi-years, I presume in this case, at least 3-4 years in totality, it's not uncommon to see total bills exceeding 50 million, between 50 and $100 million.
Wow, and I know a lawyer of your caliber in Washington, D.C., even for you, it must be a big case. But before we go, we have one last question, is that we wanted to clarify what Justice Minister Han Dong-hoon was saying. He's going to seek ways to appeal the result. And as I've mentioned in previous question, that this is not your conventional court case in the States. It's an international arbitration. So what are the options? He said an annulment, a word that's not familiar by a lot of people.
Yes. One important takeaway for any arbitration case is that the arbitral body's decision is binding and final, and this decision is no exception. But there are limited grounds to appeal that decision, and in the ICSID parlance, it's called annulment process. It's very possible that both parties in this case, not just Korean government, could seek a request for annulment. And if so, in some sense, of course, if one party seeks annulment, it could incentivize the other party also to file for a request for annulment. But whether the annulment proceedings occurs or not is a decision of the 3-member ad hoc committee from ICSID, and they will deliberate on that issue for several months. Assuming that because there are limited grounds for requests for annulment, and those grounds generally, I'm oversimplifying it here, but generally relate to abnormal or outside of the norm procedural anomalies or lack of due process or misapplication of the law. So generally annulment is not happening to re-litigate the facts or to rediscover the facts of the case. I think the facts will largely remain as is. So the parties will essentially dispute these procedural abnormalities that have occurred before the panel. And if so, then it's reasonable to assume that, assuming both parties file for annulment, it's reasonable to assume that both parties will bear certain amount of risk going forward, meaning that the standing award right now may not stand at the end of the day. So it could go up or down, which means it could really each party could bear a varying amount of risks as the proceedings go forward.
I suppose we'll have to wait and see. Sorry, but we're going to have to leave this interview here. But thank you so much for your being with us this morning, Mr. Lee. We hope to speak to you again soon.
Yes, pleased to be here. Thank you.